it's Tracey McMillan from Forged Legal, and today I'm going to do a webinar for you on divorce. Now, I've outlined for you in our previous webinars what documents you need, what the court's looking at before they'll make it a divorce order for you, and what happens when you separate and what you've got to do. But today we're focusing on the divorce procedure. So what do you actually have to do? So this is your step-by-step guide, which will work in conjunction with those previous webinars that we've done for you. So let's get started. So step one is, how do you actually get a divorce? The very first thing you've got to do is you've actually got to go to this website. It is up on the screen now on the slides. It's www.comcourts.gov.au. This is the very first place you've got to do to do anything. This is where you're going to do your online application. This is where you're going to file online. This is where you're going to pay for your divorce application. Okay, so this is called Comcourts. So www.comcourts.gov.au. What you're going to need to do is you're going to need to register and create a profile for yourself. Okay, that's what's going to give you your access. Now, once you've done that, the next step is you've got to make a decision. Are you going to file your divorce and apply for it as a sole application, which means by yourself and not with the consent of your spouse? Or are you and your spouse going to file a joint application together? It's very important because it'll change how you're going to actually do some of the procedures, okay? Now, here's the pros and cons of both, because there are pros and cons of doing it both ways. So if you're filing jointly together with your spouse, the pros is that you're not going to need to serve the documents or prove that you've given a copy of those documents to your spouse. So that saves a lot of time, potentially a bit of money, that type of thing. If you do file jointly with your spouse, then there is no requirement for you to attend court. You don't have to, once you've filed in your application and it gives you a court date, you don't actually physically have to turn up for that court date. The cons to it though is that you both, if you're wanting to get an exemption or a reduction in your divorce application fee, you're both going to have to satisfy the exemptions for the reduction in the fee to be eligible. So it can't just be if, for instance, if you're unemployed but your spouse is earning $100,000, it can't be that you can claim the exemption. It has to be either all or nothing, both of you or nothing. Okay. Now, if you're going to file for a divorce individually, like on your own, then the con obviously is you're going to have to go through and you're going to have to serve the application on your spouse. So that means you're going to have to prove to the court and fill out the forms required to show that you've actually given them a copy of the application and showing them that there is a court date that they're permitted to turn up to and answer if they wish. Now, the pros of it is that if in fact you are seeking that exemption for a reduction in the divorce application fee, then you only need to satisfy it on your behalf that you have one of those exemptions. So those exemptions, just to be really quick, is you need to have had a healthcare card, so a senior's healthcare card, a pensioner's card, or your normal, like your Centrelink healthcare card. You need to have been either in receipt of AB study or OS study, or in receipt of legal aid. So if legal aid are representing you for, say, a children's matter, then that would be enough to get you the exemption. If that's not the case and you haven't, or you have to have been like under 18 or even incarcerated. So that's a prisoner currently serving time in jail. Now, if one of those things don't apply, then the only other one is that you've got to prove that you're going to suffer financial hardship and you're going to have to go through and fill out the form that requires you to prove what your day-to-day living expenses are, etc., for the court to be satisfied with it. But only you have to prove that. You don't need both of you to do so. Now, you won't need to attend court if you choose not to, if you have filed individually, on the condition that there are no children of the marriage who are under the age of 18 years. If there are children, you have to turn up to court if you're filing on your own. Now, and that's absolutely mandatory. The court will, they will adjourn a matter off and say, hey, you've got to turn up again, and they'll give you another date. And if you don't turn up then they can actually just dismiss your entire application. So that's really important for you to know. Now, now that you've got your ComCourt's login details, etc., you've got to go through and you've got to complete the application for your divorce online. It's all done online these days. You can't fill it out by hand and then just walk it into the court anymore. You actually have to do it online. They will not receive it or accept it in any other form. Now, when you are filing your application for a divorce online, you are going to have to also upload some supporting documentation. So the supporting documentation you're going to need is your registered marriage certificate. So this is not the certificate that you signed on the day of your wedding. It's not the one that's got your handwritten signature. It is the one that looks like your birth certificate, that's typed out, that got sent to you probably a month or 2 months after your marriage ceremony occurred. That's your registered marriage certificate. That is the certificate that the court is after to prove that you're, to demonstrate evidence of your marriage. Now, if your marriage is if you got married less than 2 years prior to the application that you're making for your divorce, then you're also going to have to upload a copy of your counselling certificate. So if you're not sure where to get that counselling certificate, if you look at one of our other webinars, we've got the details there. So it's Family Relationship Advice Line can actually assist you in referring you to counsellors who can give you the appropriate certificate. But you're going to need to have that. If you're not able to attend on that counselling, then what you're going to have to do is you're going to have to upload an affidavit which outlines all the reasons why you should have an exemption from the court to not have to attend through that counselling. So that's such things as you have a physical distance issue. So one person is over in America, one person's here, so counselling's not practical. You don't know where one person's located. Maybe there's severe domestic violence. You'll have to put that all in an affidavit that you're going to have to write up yourself in order to file it in court, okay? And that's what you do online. In addition to that, you may need another affidavit if in fact you've been separated under one roof, whether it's 2 years or not. If you're saying that you have separated but you're still living together under one roof, you are going to have to do that affidavit which outlines all of those reasons why you say you're separated. So that is, you're living in separate rooms, you're no longer engaging in intercourse, you've divided up your bank accounts, you're paying your own bills, your own food, your own way. Maybe it's you're dividing up the chores, so you're doing your own chores and your own washing and things like that. More importantly, you're socializing separately, so you're not going out pretending to the world outside that you're still married, and communicating that separation to people outside of your relationship. So family and friends is fine. You may even want to upload an affidavit from that friend or family member who you've spoken to who can actually confirm that you in fact have separated. Okay, so that's a very important thing to do. You can have more than one affidavit uploaded. Now, in addition to that, you're going to have to demonstrate that you have organised and made arrangements for your children. So if you're going through a divorce, whether you're attending in person or not, if you have to attend and there are children, And then the fact is the court is going to want to hear about what those arrangements are for the children. So you may need to go through and do an affidavit. It doesn't have to be very long, but just outlining where the children are going to school, what times they're spending with each parent, how's that working, etc. So you'll have to upload that onto supporting documents with your application for a divorce. Okay, now once you've uploaded all of those things, you're going to have to pay the filing fee, or you're going to have to upload the fee exemption form. So that's on the basis of financial hardship form that you'll have to fill out. If you're not sure where to get that, go onto the Federal Court website, and they will have a form there for you to fill in for waiving the divorce fee application. Now, once the divorce is filed, you're going to be provided with your documents back. So you press the button, you've paid the fee, you've uploaded all your support documents, great. What you're going to get back in return then is you're going to get a couple of things. You're going to get a sealed copy of your divorce application. So what you filed will now come back to you with a beautiful red round stamp on it. Okay, that will be down the bottom of the document somewhere. Up the top in the right hand corner will be a little box, and it will have the date, it will have a time, and it will have an address. And this is about your court appearance date. So this will tell you when your court date is. So it'll be, let's say it's the 23rd of May and it will usually be, depending upon which registry you're in, so which state, it will be either 9:30 a.m. or 9 a.m. or it will be like 11 a.m. Or even 2, depending upon which lot you go through with. Now, let me be clearer to you about what that date means. It does not mean that you rock up at 10 past. So if the court date and time is 9:10, you don't rock up at, if it's at 9 a.m., you do not rock up at 10 past 9. You do not rock up at 5 past 9. You must expect to actually be ready to go into the court at 9 o'clock. Now, I can tell you the amount of times I've seen people turn up late and their matter has already been heard. So if you have a very efficient judge, which there are a lot around, they don't want their time being wasted. They want to get you in and get you out as quickly as possible. So if you are late, you run the risk that the matter's heard. If you're not there, they will not bring it on. They are not interested in whether you've had a car accident. They're not interested in whether you missed a train. They don't care. So as a result, please try to be at the court. Aim to be there at least half an hour before, if not an hour. Doesn't matter, you bring a book, sit around, just wait, that's fine. But make sure that you're there on time. Now, in addition with that application for your divorce application that comes back with the seal, what it's also going to give you is it's going to give you a sealed copy of the affidavit for e-filing. So it'll show that it's been filed and what day, what time, things like that. That is important because you're going to need those documents for service. Okay, so we're going to go through and do your service documents. So once you have those documents in your hand, you now have to decide how you're going to serve it. So again, if you have a joint application, you don't actually have to go through this process. So if you're doing it on your own without, involvement from your spouse, then you'll have to go through this process. So you will have to decide at the very least whether you're going to try and serve it by post or whether you're going to serve it by hand. That's your first decision. If you're going to serve it by post, if spouse refuses to accept it or doesn't collect it from the post office or anything, then you're going to have to then go through the process of going and serving it by hand. So if you don't want to do that risk of them not engaging in the process with you, then I would highly recommend it is much better for you to just bypass service by post and go straight to delivering it to them by hand. Okay? Now, here are some of the time limits. If your spouse is living in Australia, you must, and this is absolutely crucial, must have served a copy of the application for a divorce and all supporting documents to them at least 28 days prior to the divorce hearing date. So the box up in the right corner must be at least 28 days prior to then. If you have not, they will adjourn your matter off for that 28 days to be heard. That allows someone time to get their documents together, to potentially respond, time to turn up to court. Now, if your spouse does not live in Australia, so they're overseas, then you must serve them with a copy of the documents at least 42 days prior to the court date. Okay, again, if you haven't done it, if the documents only got to them 30 days out, then you're going to have to explain to the court, no, you haven't had that time frame. There is an exception. If they've signed an acknowledgement of service and they acknowledge it, the court may actually hear it. But if they haven't and they haven't engaged in the process, the court's going to adjourn it and wait for that 42 days to have lapsed. Now, once you've decided whether you can serve it via post or in person, then you've got a process. So let's go through what happens when you serve it via post. So to serve your application by post, these are the documents you're going to have to send. Firstly, when you're sending all of these, you need to send it via registered post, and you need to make sure that you are requesting someone to sign for the documents and give you a receipt back to confirm that that's happened. Okay, if you haven't got that, you haven't got evidence of it actually being served by post. So it's really important that you keep all that information from Australia Post. So the documents you're going to have to file and send is one, the sealed application for a divorce. So that's the document you filed online, which comes back with the red round stamp on it. Okay, that's the one with the court date up in the top right corner. That's the first one. You're going to have to give them also a copy of your affidavit of e-filing, which just shows when you filed it and what time, etc. In addition to that, you're going to have to give them a copy of the marriages, separations and families brochure. And that's a document which is just it's a printed out brochure. You can actually get it off the federal court website. And we'll put a link up here for you so as you actually know what the website is for you to get the document. In addition, what you would also do is send an acknowledgement of service form. You just print it out. You can get a copy of it on Concourts if you like, just print it out. And it's just blank. You don't have to fill in any of the pages. It's up to them to fill it in. Then you also want to send, it's really important, a stamped self-address envelope with your return address of whether to send it. If you don't do that, the odds are no one's ever going to send it back because it would require an effort. So you want to make sure you avoid those roadblocks by sending that envelope. Now, with that acknowledgement of service, fingers crossed, if your service via post works, he or she would have signed the acknowledgement of service and sent it back to you. If they don't, then you're going to have to go through and do the affidavit of service by hand. But if they do send back the acknowledgement of service, you'll have their signature on the bottom of it. From that, you're actually going to have to do an affidavit of service by post, which is basically just the affidavit of service, and you just tick that you sent it by post. But you're also going to have to complete the affidavit of proving signature component. And that outlines why you say it's their signature and how you can prove it. So a really easy way to do is if you have a copy of their license or some document that they've signed in the past, you can attach it to that to say, this is why I say it's his signature or her signature. So you can prove that it's actually got to the correct person. Now, when you're signing all of these, I just want to state all these documents need to be actually signed in the presence of a Justice of the Peace or a Commissioner of Declarations, which is still what you would understand as a JP, or a lawyer. One of those things people will be fine, but you do have to actually have these certified and sworn. Now, Again, if you haven't received that acknowledgement of service back, then the best way is actually to go through and do service by hand. So this is what happens. This is service by hand. Then the person who's serving it by hand has to be over 18 and it can't be you. Okay, you can't serve your own documents because you could say, oh yes, I served him, but doesn't mean it actually occurred. So the court want to know that this person's actually being given appropriate documents to know that there's something going on about them in court. So with that, all right, so the documents that you need to file or serve when you're actually serving by hand are these. You need your application for a divorce. You need your affidavit of the e-filing. You need your marriages, families and separations brochure. You will give them an acknowledgement of service form to fill out as well if you want to. And a stamped self-addressed envelope again, okay? Now the only difference is this doesn't go in the post this time. This gets handed to them. So to prove effective service by hand, then the server must clearly identify your spouse. So if you're giving it to a family member, they can say that when they do their affidavit of service, they can say, I know that this is the person we're giving it to because they're my brother-in-law, right? And I know this person, right, intimately. If you're using somebody who doesn't know them, let's say it's a friend that you've made after you've separated, or you're using a professional or some third party who's never met them, then I highly recommend give them a photo of him or her and give them the full name of the person and the address of where they live or where they're working or where they're going to be located. So when they do, they've got to go up to give the documents over. They've got to identify the person. So the easiest way is this. Hey, Billy, Bob, Jane Smith. And usually the response from people will go, that's not me, or yeah, what? Or they acknowledge it in some manner. All you have to do is get the acknowledgement from them. So in the affidavit is, I asked the person, are you Billy, Bob, Jane Smith? Person said, yeah, why? That's enough to identify the person. If they say, no, not me, but they have a photograph of the person, that is enough for them to say, I identified them because I had a visual, and they can even attach a photocopy of the photograph with the affidavit to say that's how I know I'm handing it to the right person instead of Joe Blogs down the road. So that's number one. Number two is when they ask and they've acquired that they've got to give service. Number three is they've then got to deliver them to your spouse. So you can walk up and hand something to somebody, but they don't have to accept it, right? So what do you do if they don't accept it? You do this. Let me make it simple. You go, yep, Billy, Bob, Jane Smith. And they go, yep. You go, you're served. That's all you have to do. You can drop it at their feet. You can go, they're served, and leave it there. You do not have to tell them what they have been served with. You do not have to have them take it. I have seen all manners of service of documents. Basically, all you have to do is leave the documents behind in some way and leave. Now, once they have done that, that is great. So the only other thing I want to raise in relation to that is if you knock on the door of where the person is meant to be residing and somebody other than the person who they have the photograph of or know answers the door, you can say, are they there? If they say no, they're not at the moment. You just say, the things that a server would say is, okay, I need to, can I leave these documents here for you to give them? Will you do that? If the person who has to be over 18 says, yep, that's fine, I'll give it to them, that is enough for you to prove service as well, because you're leaving it with the person there to hand it over. You'll then have to get them to, you'll have to figure out who it is you're actually talking to so they can give you the name to prove that service. So that's actually another way you can get around it as well. But once you've done the service by hand and it's all been immaculate and the person who's serving it has done such a wonderful job, they've got to come back and they've got to swear an affidavit of service. So they've got to write down what was actually said. Don't paraphrase, please. So if you hand over the documents and he says, "Get stuffed, I'm not going to take it," or "F off," then you put in your affidavits, I said, "Hi, are you Billy Bob Jane Smith? This person responded, 'Get stuffed. I'm not accepting that.'" And that is what you actually write, word for word, verbatim. You don't have to be polite here. The courts want to know exactly what was said. All right? That's really important. Then you fill out that affidavit. Once you've filled out the affidavit, you'll need to then go in and file it back online in ComCourts. Okay, so you go back into ComCourts, you upload the affidavit of service, click the button that says it's the affidavit of service and file it. That is so as the courts will know what you've actually done. Right, so everything's wonderful. You've done the application, you've got the support documents now. You're just cruising. So everything's all complete in terms of the procedural side. So now we're going to go into what happens when you actually go to court. So you decide, yep, I've got to turn up to court for whatever reason, or you choose to be there. So obviously, if you filed a joint application or you filed a single application and you don't have any children, and nobody's filed a response to the document, which is very rare, then if it comes up to the court date, you don't actually have to appear. You don't have to do anything. If that is the case and you go up to the date for your divorce, please don't jump back onto ComCourts that day and expect that a result is going to upload into ComCourts quickly. The decision or the outcome of your court date will get put onto ComCourts, and that will be how they notify you. But it will not happen immediately. It will probably take 3 days to about a week to actually get onto the physical system, because there's someone in the background typing all of that in. It's not an automated process, unfortunately. So just bear that in mind. So if you don't turn up, eventually your outcome will be there, and it will say something like divorce application granted, or order granted, or order made. That doesn't mean that that's your actual date of divorce. That just means that that part of it has been completed. Now, if you have to attend at court, so for instance, you've got children and you're filing on your own, you have to turn up, then here are some really simple, they should be stating the obvious, but people do it all the time, and it's the quickest and easiest way to make a judge angry and put them offside. So remember, they're human beings as well, so they like you to do certain things and certain protocols. So here is what they are. One, when you're going into the court, you actually will have to go through scanners and medical detectors. Do not take an aerosol can, otherwise you're going to have to store it off in the security area, or basically you have to throw it out. If you're going to take an umbrella because it's wet, that has to stay down before you go through security. They do have a bit of a section there, but try to avoid it if you can. You don't want anything too dramatic to avoid you going through the metal detectors. You can wear jewelry. I wear this to court all the time. This, don't have a problem with any of those things going through. It's just the big items that they're looking for. Now, always turn up a minimum of 30 minutes prior to the time for your court hearing, as I've stated. If you can, fill out an appearance slip. So it's a little piece of paper like this. You might see that there's a security desk somewhere on your floor, and they'll have a pile of them there. If not, when you go up to the bench, so the table in court when your matter gets called, go up there, you might see a pile of them there that you can fill out before you start talking. It just helps the judge to know exactly who you are and if you're being represented or not. Now, again, as I stressed before, do not be late. Do not be late and expect that you're going to have a good outcome. Do not be late and expect that a judge is not going to be mad as hell. All right? Dress appropriately. Do not wear tank tops. Do not wear thongs, flip-flops. Do not wear board shorts. Do not wear little singlets. I usually say to my clients, dress like you were going to go to church, or dress like you were going to go to a wedding without being completely over the top. It needs to be smart. It doesn't have to be ridiculously over the top, but it does have to be nice and presentable. You don't have to wear a suit. That's perfectly okay. But ladies, cover your arms. Okay? The other thing is, I don't care how much a judge really riles you up in this process, don't backchat. If you backchat a judge, you have to be prepared for the consequences, which is either A, they're not going to give you what you want, B, they're going to order an issue of costs against you, or C, worst case, worse, they can actually have you done for contempt of court for being rude to a judge and put you in jail. Now, I know that there is a judge specifically in the Brisbane Registry who very much would do that just like that. So do not. They are there as a sign of respect. They expect that respect to be given by everyone who appears before them. Now, I also want you to say, when you're walking into a courtroom, if you turn up before or after a judge is already underway, for whatever reason, you've had to duck out of the courtroom and come back, etc. When you open up the door to go in, please nod your head and bow. You don't have to do this, okay? But you do have to do this. And that is a sign of respect of, I'm sorry I've interrupted you. You do not speak when you go into the courtroom. If you have to speak for whatever reason, you whisper so loud, so quiet that you can barely hear you. Because a judge will stop everything they're doing to tell you to shut up or get out. Now, as you leave a courtroom as well, let's say your matter is finished and you're turning around to leave the court, what you would do is normally you wait at the court table until such time as the next matter is called up, unless the judge says, yes, you can go. But regardless of all of that, when you're walking out of the room, if a judge is still sitting up in his chair, you turn. When you get to the door, you turn and you nod before walking back out. Again, it's a sign of respect of, I apologise for opening the door and disrupting what's going on. Now, the most important thing out of all of that is you need to practice what you're going to say. So there is nothing worse than people who are self-represented who turn up to that actual bar table and have no idea what they're going to say, have no idea what they're after or why they're after it. Okay, so you don't need to be a lawyer, you don't need to be a scholar, you don't need to be, you know, Jesus Christ being the best orator in the world or Socrates, but you do need to know exactly what you're going to try to say to a judge and have it written down in front of you. If you want to, write it word for word, if that helps. I've seen many a junior lawyer do that when they first go to court for the first few times. So, some of the questions the judges are going to ask you in a divorce application is this. When did you separate? Okay, so they're going to ask you those things. When did you separate? Possibly how you communicated that separation. Was it your intention of both parties? So you outline your heading. When did I separate? How? What occurred? The next one is the court's going to want to know that you have been separated for 1 year and 1 day. I like to make it really easy for a judge. So when I get into court, I want to tell them everything that they want to hear, which is already in the application. And I know what you're saying or probably thinking, that it's already there in the application. But if you're one of 20 matters that are before them, do you think they really want to go through and read every single application that's before them? Or do you think that they'd rather someone tell them so as they make it easier for them and quicker for them to make a decision? They're also going to ask, well, has the relationship broken down irretrievably? And what arrangements are in place for the children? So if you have separated, then I would recommend you do something along the lines of this. Good morning, Your Honour. My name is Tracey McMillan. I am representing myself. I have a divorce application before you. Your Honour, me and my partner, my spouse, separated on the 1st of May 2019. It has been a year and a day since that separation has occurred. The application was filed in June of 15th of June 2020. Thereafter, there has been a year and a day prior to the application being filed. Your Honour, the marriage has broken down irretrievably and there are no prospects of the relationship being reignited. Your Honour, there are 3 children under the ages of 18. Arrangements have been made for the children. We have a parenting plan in place which is attached to my application. Now, if you have been separated under one roof, you might say, Your Honour, I have filed an affidavit dated the 10th or 15th of June 2020, affidavit of Tracey McMillan, and that goes to outlining the arrangements for the children. In summary, the children live with me on a 2-week basis for the first week from 9 a.m. Monday until 9 a.m. the following Monday. My spouse and I have half of all school holidays, and the children are currently attending Pine River State High School and are progressing well. There are no health matters in relation to the children. So if you can see with what I just did for you then, is I basically just told the judge exactly what's in my application without them needing to go through it all. A judge would be very grateful for that, and it means they can get through their matter quickly. So if you can do that, by all means do it. If you can't, that is fine. It is there in the application. They're used to people turning out without it. But try and make it nice and succinct for you. The other thing the court is going to want to know is, when did you serve the application? If you're representing yourself, if you filed yourself, when did you serve the absolute application? So then, if the judge, or it could be a registrar, by the way, it's either or, just refer to them as Your Honour. But either way, hopefully, fingers crossed, there'll be no hiccups and they'll make the order. If there is a hiccup, they'll usually adjourn it off and ask you to do certain things and then come back the next day. So, great. The court will then say something along the lines of, I refer to the application filed on the 15th of June for a divorce 2020. I refer to the affidavit of blah. They might reference I read the affidavit. That is just a technical legal term. They will go through all the documents and the service documents, and they will say things like, I am satisfied that the parties have been separated for a year and a day. I'm satisfied that the court has jurisdiction to hear this matter. I'm satisfied that the relationship has broken down irretrievably and there are no prospects of the resumption of cohabitation. The court will then say, based upon those issues, I find that the court will grant the application for a divorce. Now, that doesn't mean that you have your divorce. What it is the court will grant you something called a decree nisi. So if you get any paperwork back in that time, you might see at the top of it, decree nisi, which is N-I-S-I. What that means is that your divorce will not be final until until that order has been in place for 28 days. So it's 1 month basically. So 1 month from that time, and only after a month has lapsed, will that divorce be called or changed to a decree absolute, and then your divorce certificate is issued. And it is that date which is your date of divorce. The reason of the 28 days is there, to put into context, is so that if somebody does not agree with what order was made by the court, they can appeal it. So there's always that room. It's very rare that it ever occurs. It's only in the most complex of matters. And for most people, it's just merely a procedural thing. So it's 1 month after that date that it will become final. When that happens, then ComCourts will upload your divorce certificate. And then, ladies and gentlemen, you have your divorce and you can now go on and get remarried if you in fact choose. So that is what the process is. If you have that divorce certificate, I just want to stress, keep it in a safe place because you're going to need it if you ever do decide to get remarried or for other random things. So it's actually absolutely important. If you lose it for some reason, you can jump back onto ComCourts and download another copy of it. That's perfectly fine. So it's important to remember, and I just want to stress finally, one last thing. Once you've issued your divorce, you've got your certificate, you're like, woohoo, home and host. I just stress this. If you have not gone through and divided your assets yet, you now have 1 year to have either divided it and got a consent order or a binding financial agreement in place to figure out who's keeping what, or 1 year to have filed in the court, the family court, for an application to go through and divide your assets. If you do not do it, then you are now statute barred, which means the court will prevent you from bringing any application to divide your assets unless you can prove an exception or a reasonable excuse as to why you did not comply with that time limit. That adds time, that adds money, and that adds complexity. So don't do it. So put it big, bold, on your fridge, in your diary, anywhere to make sure that you actually go through and do it. Now, ladies and gentlemen, that is the end of the webinar, and hopefully by the end of that, you'll have a clear understanding of exactly what it means to go through and get your divorce. Now, if you're sitting there going through that process and going, okay, I need some assistance right now with the actual application, then what we've done is I've actually created a workshop for you where you can actually register below. And what we're going to do in that workshop is you're going to have your divorce application form, which will be online with ComCourts, and I'm going to walk through step by step every single question that's on there. So at the end of it, you can have all the questions answered and filled in and completed. So at the end, all you have to do is press a button and you're ready to file it on ComCourts. So I will be there. It's very interactive. We're limiting our workshops down to no more than 15 people so that we can answer all the questions you have and make sure that you're getting quality and getting all those questions answered properly and taking that time to get it done. If that's of interest to you, by all means register down below and I'll look forward to seeing you at that workshop. If you, from here, you're wanting to know a little bit more about maybe it's the divorce documents or separation and what other things you need to consider, well, we do have 4 webinars in this series that you're welcome to click on, and we'll put some links below for you to help you educate yourself through this process. Otherwise, good luck, and I hope you have a smooth, clean and easy divorce. See you later.